Well, ladies and gentlemen, welcome to this symposium on the law of cousin marriage, sponsored by the Pharos Foundation and hosted by the Woolf Institute. Pharos is a research and public education institution founded in Oxford last year in an effort to fund and promote research in fields that have been politicised, neglected, or under-resourced for far too long. A subject such as today's, which touches on every great theme of human existence, love, hate, sex, disease, death, violence, corruption, and much else besides, is exactly the type of topic that requires, but hitherto lacked, serious discussion by serious experts. The last time cousin marriage featured prominently in public debate in the UK was during the mid-Victorian era, when no less an authority than Charles Darwin sought to include a question on first cousin marriage in the 1871 census. Parliament, of course, rejected this outright as being, quote, particularly sensitive and unacceptably intrusive. And it's not been brought up in a serious way since. Nevertheless, this past year has seen a resurgence in interest in cousin marriage across the Western world, with no fewer than 4 states, Tennessee, Norway, Sweden, and Denmark, announcing or implementing bans on cousin marriage in their jurisdictions. Tonight's open discussion will cover all aspects of cousin marriage in English law, the legal history, public health implications, the social impact and group dynamics, clanism and politics. But first, however, we will hear from 2 highly distinguished legal experts who will deliver our keynote lectures tonight. First, we're delighted to be joined by Professor Rebecca Probert from the University of Exeter, the foremost expert on English marriage law and special advisor to the Law Commission's Marriage and Weddings project papers, which ran from 2015 to 2022. Tonight, she will talk on cousin marriage and the history of the prohibited degrees in English law. We are equally privileged to be joined remotely by Nazir Afzal, OBE, who's a highly distinguished solicitor, former senior prosecutor at the CBS, and the current Chancellor of the University of Manchester. Nazir's lecture tonight is titled Revisiting Cousin Marriage, the Case for Thoughtful Legislation in a Changing World. So without further ado, please welcome Rebecca and Nazir. And Rebecca, over to you.
Well, thank you very much for that introduction, Patrick, and for the invitation to come and talk to you this evening on this topic. So, all societies have rules on who may marry whom, and that these rules differ from place to place and from time to time. Sorry, Mira, can I have the next slide, please? Has led some to conclude that having a rule is more important than what that rule might be. So this is the sort of view put forward by Sybil Wolfram in her book on in-laws and outlaws, where she suggests that the rule prohibiting marriage between relatives serves no more tangible a purpose than marking off relatives from non-relatives. Why do we suppose that customs that appear to mark categories have any particular purpose beyond just that of marking categories? Others, by contrast, see the rules as going deep into the structure of society itself, a comment by the Bishop of London in his speech on one of the many pieces of legislation aimed to reform this area. Now, my aim in this paper is to answer a rather simpler question, which is why we have the rules we have, and so situate the debate about cousin marriage in the context of the history of the prohibited degrees in English law. And Patrick's introduction sort of set it up quite nicely in terms of the lack of serious consideration that's really been given to the prohibited degrees. So I'm going to be talking about the origins of the permissive approach to cousin marriage, showing that it was personal and political rather than principled. And then the real mess that the law relating to the prohibited degrees was in over the next sort of few hundred years. And then finally look at the debates on the lifting of various prohibitions and how cousin marriage was very much used as a sort of touchstone, a reference point throughout those debates. Basically, when anyone was trying to argue that a certain set of relations should be permitted to marriage, they inevitably said, well, cousins are able to marry, so why not XYZ category as well? I'm going to start with the relationships that are forbidden in Leviticus, with a certain degree of trepidation given the sort of expertise in the audience, but I think it's important to look at them because they are specifically referenced in the statute. So Leviticus isn't actually about marriage, it's about sex primarily, and who is prohibited from having sexual relationships with whom. So it starts off with this unambiguous and very general prohibition that no one is to approach any close relative to have sexual relations, before going on to list various specific relationships, as well as the spouses of certain relations and the relations of a sexual partner. So this final category here, saying that if you've had sex with a woman, you should not also have sex with her daughter or granddaughter. Now, I think certain problems are obvious when we look at this list if we're using this as a basis for legal regulation. So first of all, it's clearly not a complete list. You know, we could perhaps assume from that general prohibition that is to cover other close relationships who aren't actually named on that list. And you might have noted that daughter doesn't appear on that list, or grandmother, again, which are relations where you would think that sex and marriage would obviously be prohibited. So if we're to assume that these relationships are covered by the general prohibition at the start, can we also assume that this encompasses other close relationships who are also not mentioned in this list? Second problem with the list is that it's couched in terms of who a man may not marry. So this immediately raises the question of, do equivalent prohibitions apply to women? So we were talking before at the start about how it specifically refers to not being able to marry your aunt, although it does specify exactly who is meant by that. But uncle-niece marriage was seen as permitted under Jewish law. So clearly these don't apply unproblematically to women. And then there's also the time-limited nature of the prohibition on marrying one's wife's sister. So, you know, the prohibitions on marrying one's deceased wife's sisters have sort of played a big part in the history of English family and marriage law, as I'll come on to discuss. But what Leviticus actually says is, and this is a most modern translation, do not take your wife's sister as a rival wife and have sexual relations with her while your wife is living. Another version of it says, you know, do not take your wife's sister as a wife to vex her. So clearly we're talking in a context here where polygamy is generally fine, but don't marry your wife's sister because that's really going to annoy her. And then we also have in the book of Genesis, the story of Jacob, Leah and Rachel, a precedent for marrying two sisters while both are alive. So certain tension between different parts of the Bible on what is permissible. So based on this kind of set of prohibitions, the canon law, and again I'm slightly nervous about talking about the canon law here, basically prohibited, and next slide please Miriam, marriages between blood relations in the direct line of descent, so including daughter and grandmother in the list, but it also expanded the scope of who was defined as a close relative, so bringing in uncle, niece, at least within the sort of Christian canon law, and cousins. At one point, this extended to the 7th degree of consanguinity, which would include a third cousin, i.e. those who share a great-great-grandparent. But from the 4th Lateran Council in 1215, it was narrowed to the 4th degree, so first cousins only. It also, based on that prohibition about not having sexual relationships with a woman and her daughter and or granddaughter, prohibited marriages with those related by affinity. So the idea is marriage made husband and wife one flesh. So your spouse's kin are your kin for the purposes of marriage. And affinity was also created by sex, so you're also prohibited from marrying the relative of any sexual partner. However, dispensations could be granted to allow a marriage within the prohibited degrees. And, next slide, this is what Henry VIII had done in order to be able to marry his first wife, Catherine of Aragon, who was the widow of his older brother Arthur. Yes, and just the next. And of course, this is all going to be very familiar to anybody who's been watching Wolf Hall. So by 1525, Henry has become infatuated with Anne Boleyn and wants to free himself from his marriage to Catherine. So we have the First Succession Act in 1534, which is designed to invalidate the marriage to Catherine, who's out, and validate the marriage to Anne Boleyn. So it narrows the prohibited degrees, implicitly allowing cousin marriage, but also any relationships of affinity based on sex alone. So in order for a relationship of affinity to operate as a bar to marriage under the 1534 Act, and my usual terrain is the 19th century, I have to say, so many times I put in 18 rather than 15 with preparing this. The marriage has to have been consummated, so it's marriage plus sex that creates the prohibition. And this gets rid of Catherine on the assumption that she had had sex with her husband Arthur, Henry's older brother, although that was a much disputed and controversial point. And it also removes the objection to his marriage to Anne because Henry has had sex with her sister. So we have an act cleverly crafted to suit the needs of a particular individual. And then, of course, it all goes wrong, and he's trying then to show that the marriage to Anne was never valid in order to free himself to marry again. So 2 years later, we have this Second Succession Act, which reintroduces the possibility of creating affinity on the basis of sex alone. And I have to say, it's not often you sit laughing while reading legislation from any era, but the two Succession Acts and the Marriage Act of 1540 that I'm going to look at in a moment are just so ranty and so mealy-mouthed in other respects. So I've included this particular line, if it chance any man to know carnally any woman. You're going, yeah, we're not really talking about chance here, are we? We're talking about a very deliberate provision. So you can say, oops, no, this marriage was clearly never valid, and be free to marry again. And then by 4 years later, we're on to wife number 5. And this is in the text of the Marriage Act of 1540. And again, it's another rant about the role of the ecclesiastical authorities. So it is attacking their practice of granting dispensations, saying this was always all about the money. And they have been questioning these marriages between cousins, which are absolutely fine and not problematic at all. And the one reason, of course, why they're so keen to emphasise this is that Catherine Howard is the cousin of Anne Boleyn. So they have to stress that cousin marriage is fine, to emphasise that this new marriage cannot be impugned. And it concludes with this really problematic statement: no reservation or prohibition, God's law except, shall trouble or impeach any marriage without the Levitical degrees. Okay, so we're using the Levitical degrees as our touchstone, but we've also got this reference to God's law, which may also be used as a reference point to impugn a marriage. Now, I think if Catherine Howard had borne Henry a child before she fell out of favour and was executed for treason, we might have had a further legislative enactment outlawing cousin marriage, or a spouse's cousin, or a cousin's spouse, to ensure that that child was not in line to succeed to the throne. In the event, there was no need for any further tinkering. The 1540 Act was repealed under Mary but restored under Elizabeth, and remained on the statute book until consolidating legislation was passed over 400 years later. So the problem, of course, was that the 1540 Act, as we've seen, relies on Leviticus, with a hint that other relationships might also be prohibited. And we do see in the 1560s various challenges being brought to the law, men claiming that they are perfectly entitled to marry their deceased wife's sister because this is not prohibited in Leviticus. So we have Archbishop Parker in 1563 setting out the table of kindred and affinity, and all the relations that an individual might be prohibited from marrying. And here, finally, we have a gender-neutral approach in that it lists it for man and woman equally and works it through very logically in terms of the same prohibitions applying to both. Now, this next point doesn't have anything directly to do with cousin marriage, but I think it's worth noting just to show how politicised and problematic the development of the law in this area is. So what you basically have from the late 16th century is a constant battle between the common law courts and the ecclesiastical authorities, battling for supremacy. You have the common law courts issuing prohibitions to the ecclesiastical courts to stop them dealing with certain matters. And they decide that because the prohibited degrees are set out in statute, even a statute that refers to the Bible and God's law, it is the common law courts that have the power to interpret it. So they can say this relationship is not within the prohibited degrees and issue a prohibition to the church courts to stop them even considering it. So that was the case in Harrison and Burwell, which involved a marriage with a great uncle's widow, not one of the prohibited degrees. And the common law courts could also prevent the church courts from hearing a dispute over the validity of the marriage within the prohibited degrees after the death of one of the parties. So this led to the sort of characterisation of marriages within the prohibited degrees as voidable rather than void. And we have, next slide, evidence of people evading the prohibition. So this is Matthew Bolton giving advice on how to get married despite the prohibition on marriage to a deceased wife's sister. Say nothing of your intentions, but go quickly and snugly to Scotland or some obscure corner in London. Take lodgings to make yourself a parishioner. When the month is expired and the law fulfilled, live and be happy. So as long as nobody actually challenged the marriage during the party's lifetime, it was unimpeachable. And that seems particularly problematic when it comes to marriages within the consanguineous degrees, as opposed to marriages to affines. And these didn't actually ever come to court because I don't think you had many examples of a man marrying his sister or daughter or mother. So the chance for the courts to say that these were void rather than voidable never actually arose. However, Marriage Act 1835 does effect that shift. So we have past marriages to those related by consanguinity remaining open to challenge. Past marriages to those within the prohibited degrees of affinity are now valid unless they're already annulled, but future marriages within the prohibited degrees are absolutely void. Now, this hardening of the rules reignited the debate about which relationships were actually within the prohibited degrees. Were these to be determined by reference to the legislation passed in 1540 or by reference to the 1563 Table of Kindred and Affinity, which had been approved by the Church in its canons of 1604. So this is where the prohibited degrees intersects with my work on bigamy. Issue came to a head in 1846 with the case of Chadwick. So James Chadwick first marries Hannah, who dies. He then marries Anne, her sister, and is told, no, actually, this marriage is void under the new law. You're not entitled to marry her. So he leaves Anne and he goes and marries Eliza, who is not related, as far as we know, to either of his wives. And he's put on trial for bigamy. Now, the magistrates' court actually just dismisses the case. They sort of say, well, no, marriage to a deceased wife's sister is void. If you're not validly married, you can't be guilty of bigamy by marrying again. But there are sufficient people with an interest in this matter being tested at a higher level for him to be brought before the assizes, where the judge, faced with these big questions about biblical interpretation and the authority of 16th century legislation, essentially boots the case upwards for decision to the Queen's bench. So Chadwick is technically found guilty because that's the only way to get the case referred up. And The length of the judgment in R versus Chadwick is a kind of indictment of the uncertainty of the law. I think this is 300 years after the legislation has been passed, but they're still debating what exactly the prohibitions are. This was clearly not something that was certain. I should have mentioned the 1835 Act doesn't have a convenient list of which relationships are affinited, it just refers to consanguinity and affinity without specifying which relationships. Anyway, so Court of Queen's bench decides, yes, marriage to a deceased wife's sister is prohibited, and so Chadwick is not guilty of bigamy. Over the course of the 19th century, we then have lots of bills to try to lift this particular prohibition. And as I mentioned at the start, you have cousin marriage being constantly referenced in those debates. 20th century finally sees the lifting of those prohibitions, first to deceased wife's sister in 1907, and then to deceased husband's brother in 1921 in the wake of the First World War. So this is very much one relationship at a time, picking off the list of prohibitions. You get a glut of them going in 1931, so aunt, uncle, niece, nephew, or the spouses of any of those persons. You also then have various changes reflecting broader shifts in family law. So you have the 1926 Adoption Act, which puts adoption on a legal footing for the first time. And that creates a new prohibition between adoptive parent and adoptive child, but not any other relationships within the adopted family. You have the Consolidating Marriage Act 1949, which finally actually includes a list in statute of the relations that you are prohibited from marrying, slightly belatedly, but now at least offering clarity. And you have the Marriage Enabling Act, which has a slightly less helpful title than some of the others, but is basically allowing for marriage after a divorce. So the 1907 Act only dealt with marriage to a deceased wife's sister. This allows marriage to a divorced wife's sister or divorced husband's brother, etc., etc. Now, this was following the recommendations of the Morton Commission from the 1950s. But it's quite striking how limited the discussion of the prohibited degrees actually is within the Commission. So it's a chunky report. It's looking at all issues relating to marriage and divorce. It is tasked with considering whether any alteration should be made in the law prohibiting marriage with certain relations by kindred or affinity. In the event, it only considers marriages to affines. That apart, it concludes by simply noting, we see no reason to recommend any further change in the law relating to the marriage of persons within the prohibited degrees of relationship. So one line in this otherwise very comprehensive report. And no mention was made of any representations had been made to it. Now, when the Law Commission came to look at nullity in the late 60s, it too gave brief consideration to the prohibited degrees. And it does briefly touch on the issue of cousin marriage. It indicated that it would welcome advice on whether a marriage between an uncle and niece of the half-blood was any more objectionable than a marriage of first cousins, and whether a marriage between first cousins was objectionable if their respective parents were two brothers who married two sisters. But it concludes by saying that it doesn't think that changes are necessary. So in its list of consultation questions at the end, it's sort of saying, well, feel free to write in with any thoughts on this point, but we're not actually recommending any alteration. And the report 2 years later simply noted that the almost unanimous view of those who commented on our working paper was that the law should remain as it is. Again, no mention of what the ones who didn't agree with that said, or how many of them there were. So no changes resulted from the Law Commission's recommendation, but within the decade there was pressure to reform the law again, this time to remove the restrictions on marriages between a parent and the former spouse of his or her child, and between former step-parent and stepchild. So the couple here actually had a private act of Parliament passed to enable their marriage. And again, inevitably, the individual beginning the reading in the House of Lords started with, "For a long time you have been allowed to marry your cousin." And then, "I agree that marrying your cousin is not quite the same situation as that which we are discussing at present, but I hope your lordships will give a favourable answer to this request." So again, the tendency just to shoehorn in references to cousin marriage, whatever the prohibition being discussed was. So the 1986 Act allowed a marriage with the child of a former spouse if two conditions were satisfied. First, that both parties to the marriage were 21 or over, and second, that the younger party had not at any time before attaining the age of 18 lived in the same household as that person and been treated as that person as a child of the family. It also allowed a marriage with the parent of a former spouse, again on the condition that both parties had attained the age of 21, but here with the additional condition that both of the other spouses had to be dead. And this came under challenge in 2007, and both conditions were removed as a result of that remedial order, neatly 100 years after Parliament had first removed the prohibition on marrying a deceased wife's sister. So, to tie all this together and set up the next stage, official discussions of the prohibited degrees, I think, have always been partial and personalised, ranging from Henry VIII's attempts to delegitimise the marriages he wanted to get rid of and legitimise the marriages he wanted to contract, all the way through to the private acts of Parliament authorising individual marriages. And again, going back to the point Patrick made at the start, at no point do we actually have any in-depth, systematic review of the law. The consideration given to the issue by the Morton Commission in the 1950s and by the Law Commission in the late 60s was pretty cursory. And throughout the debates on whether any specific relationship should be removed from the list of prohibitions, cousin marriage has been a consistent reference point, suggesting at least some disquiet about that possibility.